Hello, everyone. Good morning or good afternoon, depending on where you're joining us from. Welcome to this webinar, where we will try to hopefully address some AI-generated content moderation dilemmas. As more people are joining in, I take the opportunity to introduce myself. I'll moderate this session. I am Maria Giovanna Sessa, research manager at the U Disinfolab. And for those of you who still don't know us, we are a nonprofit organization gathering knowledge and expertise on disinformation in Europe. And we organize these webinars almost on a weekly basis in order to give voice to experts in our community, to share knowledge, and to raise awareness around the excellent work that is being done by so many. Before we begin, let me give you some housekeeping rules. As you might have noticed, walking in, the webinar is being recorded and it will be uploaded on our YouTube channel and website. You can also enable a caption and translation function. If you would like to do that, you can click on the CC at the bottom of your screen, enable the translation option, and select your desired language. Just a reminder that we are going to have a Q&A session after the presentation. We will be using Slido as usual. Please don't post your questions on Zoom chat because we will be unable to see them. And if you want to start connecting to Slido, you can either scan the QR code that you see on screen, or you can go to slido.com and enter the code disinfo. I encourage you to connect already, and I also invite all attendees to submit the questions anytime during the presentation. You don't need to wait until the end, so we can quickly return to them after the presentation. And in order to get you acquainted with the tool, our usual opening questions, please go on Slido and let us know where you are joining us from today. I am in Milan and our speaker is in Tilburg. Okay, so Vienna, Madrid, nice. Brussels, of course, big bubble. All right, Turin, Berlin, fantastic. As you keep them going, Paris, New York, fantastic. Georgia, welcome. The next question is going to be, which sector do you represent? We are, Udosivov, as you know, is an NGO, so we are civil society. Our speaker is from the academic sector. Fantastic. Thank you. So moving now to the topic of the webinar today, we're going to speak about generative AI. And Gen AI is challenging the core assumptions of the Digital Services Act by blurring the lines between platforms that host the content and systems that actively create said content. So today we'll explore whether and how generative AI fits within the Digital Services Act, highlighting the legal gray areas around responsibility, liability, and the governance of AI-generated content in an evolving digital ecosystem. And today's speaker for this very important topic is Professor Marco Bassini, who is an assistant professor of fundamental rights and artificial intelligence at the Tilburg University and a research fellow at the SARE Center on Regulation in Europe. He also teaches various master and bachelor level courses, acts as principal investigator for a project called Retrain on enforcing constitutional rights in the generative AI age, and is one of the experts selected by the European AI Office for the drawing up of the General Purpose AI Code of Practice. Professor Bassini has over a decade of experience combining academic research with legal practice, including advising the Italian Communication Authority and the Italian Ministry of Technological Innovation. His expertise spans data protection law, AI regulation, and media law. So welcome. And Marco, if I may, thank you for joining us. And I'll leave you the floor now and see you later for the Q&A. Thank you.
Thank you so much. I hope you can see my slides, and um, it's a pleasure being here today and to have the chance to discuss with you a very interesting topic in my view, which is the intersection of the AI Act and the Digital Services Act, in particular with respect to specific aspects, namely content moderation regime and AI generated content. Um, I would love to start this conversation just recalling some of the recent developments we could notice. Maybe those who in the Brussels bubble could more immediately get some of these quite interesting developments, while maybe in other countries there is less attention, but as you know, there is an interesting, important investigation of the Commission into Grok and X recommender system that has been launched under the Digital Services Act. Particularly, it will basically consist in understanding whether the integration of these AI chatbot into the service operated by X complied with the provisions under the DSA, particularly with respect to the risk mitigation measures based on the previous assessment of systemic risk. So Article 34 and Article 35 of the Digital Services Act, which are two very important provisions. I'm going to mention them today concerning basically the risk governance framework we have in the Digital Services Act. So this investigation was quite resounding because it seems to be one of the first opportunities for the European Union and particularly for the Commission to test the existing framework and in particular the Digital Services Act with respect to developments we have in AI technologies. The fact that there is an integration of AI technologies into digital services under the umbrella of the DSA is definitely something very interesting that in my view, is worth exploring also in its deeper political and policy and legal implications, because I believe this has been a bit underestimated in its actual framing in the lawmaking process in the AI Act, but also in the discussions that were ongoing in the past months. And now, more recently, the European Commission seems to be very interested in understanding whether a system like ChatGPT will fall under the umbrella of the DSA, and accordingly, this will trigger a series of obligations that are really relevant and that may be very interesting applied to AI system and particularly to Gen AI system. So, just for you to know, OpenAI announced that the service operated reached a very important threshold over the 45 million users that is set under the DSA. So this per se is just a piece of news that is not determining any legal consequence per se. But of course, this raised the attention by the Commission regarding the possible qualification of this service under the umbrella of the DSA. And of course, this raised quite interesting debates on whether this and other similar services could be qualified under the umbrella of the DSAs as VLOP or VLOS. I will explore these concepts later on because I take it for granted that some of you are already familiar with them, but others might not be so much familiar. So I will briefly sum up the architecture of the DSA and explain why it is important that when some particular systems and particularly generative AI systems may fall under the scope of application of some obligations of the DSA, and what consequences this may have. Just briefly for you to know, these are quite interesting provisions, but before delving into their contents, I would like to very generally recall the role of the DSA and the AI Act in the European Union Digital Rulebook. We know that the Digital Services Act was passed in 2022, and it was passed with a view to modernizing the legal framework applicable to digital services after the repeal of the e-commerce directive, which in a way was quite outdated, and it maybe was already outdated before the Travapportato for the Digital Services Act. It was quite visual in some national court cases that the e-commerce directive and the national implementations that member states gave to these provisions were not easily accommodating the evolution of the markets and also the significant presence gained by some companies in particular. So there were a lot of discussions around the possibility that this legal framework was eventually amended. In the end, the Digital Services Act came into being in 2022. It actually came into force and became applicable. And as we know very well, the DSA concerns digital services, which of course, may be very different in nature, may have very different characteristics and features, and accordingly, they may trigger different requirements and obligations. What is interesting to note, however, and this is the most important difference we can spot compared to the e-commerce directive, is that the DSA acknowledged the sophistication, the inherent sophistication of digital services and of their providers. So in the end, there is a differentiation of the requirements and obligations applicable depending on the scale of their business, depending on the nature of the business. We have a new concept that comes into play, the concept of online platforms, and the concept of very large online platforms for those those online platforms reaching a certain threshold. And the idea behind the DSA is that in a way, the bigger a platform is, and the more relevant is its business, the more, of course, the services may have an impact on society, and particularly on the public sphere and on freedom of speech and other fundamental rights. So the obligations will be stricter. And in the case of very large online platforms, for example, compare to other services, other digital services that equally fall under the scope of the Digital Services Act. However, when the DSA came into force, let me say, of course, there was awareness that more and more activities were performed through algorithms. For example, recommender systems are something that is already under the DSA, but the DSA is not looking per se at AI. Just recently in the European Union, we got the AI Act, and we have a legal framework that is very detailed and very complex. There are a lot of discussions concerning the possible postponement of some of the obligations and the AI Act regarding the so-called digital omnibus on AI, which are currently, of course, a very hot topic. But what I want to say is that both branches are, of course, meant to regulate something which is quite different. So the DSA digital services, the AI Act, AI systems and models. And also the recipient of their obligation should, in theory, be different. When it comes to the DSA, the focus is on the providers of online platforms or very large online platforms. Generally speaking, we can say the providers of intermediary services, which is, I think, a quite telling language. I will touch upon that particular aspect later on. While the AI Act is focusing, as we know, on AI systems and general purpose AI models. So it's something which per se is not necessarily connected. However, we know that it's very frequent that AI models and AI systems can be developed and deployed by certain actors, operators already under the umbrella of the DSA because they are very large online platforms, for example. So, in a way, the AI Act has some recitals that try to connect in a way its provisions to the DSA. And these are exactly the provisions that we are about to comment on very briefly, just to understand the way the DSA and the AI Act in a way speak each other. It wouldn't be accurate to say each other indeed, because of course it's the AI Act which is in a way trying to draw some connections between its that framework and the DSA. But let's try to focus on what we can find in the recitals of the AI Act, and then we will discuss which are, in my view, the problems and what is not being said under the DSA and the AI Act, which might be relevant and very relevant for the application of the DSA. First of all, Recital 118 says that to the extent systems or models are embedded into designated very large online platforms or very large online search engines, so VLOP or VLOS, they are subject to the risk management framework provided by the DSA, uh, which is quite understandable, and it's in a way something quite easy to understand. If you are an AI system and an AI model, and you are integrated into something that is already under the umbrella of the DSA, the risk management framework will become applicable. And the consequence of that recital and that first line, let's say, of the recital is in the second line that you can see here. So the corresponding obligations of the DSA, that the AI Act, are presumed to be fulfilled. So the idea is that if that system or model is integrated into a service under the DSA, there will be some obligations depending on the status of the VLOP or VLOS, and accordingly, the framework, the risk governance framework under the AI Act is presumed to be fulfilled. So by complying with the DSA, you are basically complying also with the AI Act, unless significant systemic risks not covered by the DSA emerge and are identified. This is an interesting point that we should also consider, maybe, because it's a possibility, and this might raise some issues from a practical aspect. The second recital is interesting as well. It just says that AI systems subject to the AI Act might be provided as intermediary services or parts thereof under the DSA. And the DSA should be interpreted in a technology neutral manner. So, in a way, this is also an explanation that uh, illustrates why the AI Act is focusing on a given specific technology, which is AI, and the DSA is more generally and broadly looking at digital services, no matter which is the technology concerned. It is possible that AI systems are integrated, as we said before, but also that AI systems are provided themselves. ChatGPT, for example, can definitely be used as a search engine. It's more or less similar to what we can expect in a search engine service. We can look for something by using a prompt, and we can obtain some results. We will discuss this also later on, because it's an interesting interpretation about the possible qualification of certain Gen AI systems like ChatGPT as search engine services. There is another point that I want to stress, but it's not the core of the conversations we're having today, so I will be more brief on this, is that, of course, the fact that under the AI Act, there are certain obligations on providers and deployers of certain AI systems is quite favorable and is facilitating compliance with the obligations under the DSA. Why? Because this will help detecting and disclosing that certain outputs are artificially generated or manipulated. So, since the DSA is quite demanding in requiring providers, in particular very large online platforms, to implement some particular measures and to take into account sometimes also the possible artificial nature of content. What we see under the AI Act might be relevant also in that respect. In the end, there is also something regarding an aspect that, in my view, has been quite underestimated in the debate, which is the application of the notice and action mechanism for hosting services under the DSA, and in particular the provisions on the liability of providers of intermediary services. Article 2, paragraph 5 of the AI Act establishes that the AI Act will not affect the application of those provisions. So we can get to understand that the DSA applies to AI systems and models to the extent they are integrated into VLOOPs or VLOs. It makes sense to us because we saw that particular connection in recital 118. However, uh, we should also acknowledge that the AI Act is referring mostly to the risk governance framework, so to the obligations to be adopted for assessing and mitigating possible systemic risks. So if you look at recital 118 and 119, we don't see any specific reference to the content moderation regime. So they just say that the obligations under the DSA will basically establish these presumptions that also the AI Act is complied with. Um, Even if it's interesting and remarkable that the AI Act acknowledges that AI systems can be provided themselves as intermediary services or part of intermediary services. So I have two questions, and these are the questions that I will try to answer today in the, I think, 15, 20 minutes I have left. What about Gen AI systems provided as standalone solutions? Why I am making this point? Because if we go back to the previous slides, and you can definitely notice this in recital 118 and 19, you see that the AI Act refers to the integration. So all these provisions seem to imply that we are talking about a AI system and AI model that is integrated within a digital service, and therefore is covered by the DSA because of that particular integration. But we know that there are systems that can be run as standalone solutions. I mentioned before ChatGPT. That's an example. Of course, that particular service can be integrated into digital platforms, but also can be offered as a standalone solution. So, should we interpret the DSA as implying that what is not integrated into into services covered by the DSA, and particularly into VLOP or VLOs, shall never be applied the provisions of the DSA? Or can we say that it's reasonable to expect that even certain solutions offered as standalone software, for example, they can fall under the obligations and provisions of the DSA? And then the second question, which is basically consequential. What about the content moderation framework under the DSA? Because we know very well, and for those of you who are not familiar with the DSA, I'm briefly summing up the content. We know that the regulation of online services and digital services is based on the general understanding that when it comes to intermediary services, there is no editorial control. So we are talking about services operated by actors that are different. Our service providers are different for content providers. They are not content creators. They are generally facilitating the dissemination of third-party content as access providers, as search engines, or as hosting providers, but they are not the publisher, let's say, of that particular content. And so we are generally considering the actors that to which the DSA applies as service providers, and in this case, in particular, intermediary service providers. So this framework makes sense, and it comes from the e-commerce directive, where basically the new lawmaker wanted to, let's say, exclude direct liability for third-party content for service providers, for internet service providers. Then we noticed that except for Article 2, Paragraph 5 of the AI Act, there is no mention of the content moderation regime and the liability exemption. So should we expect that also the content moderation regime under the DSA applies to Gen AI systems? And the reason why I'm making this question is not just that we have a matter of, let's say, connection between the DSA and the AI Act, but is also related to the fact that we are discussing what kind of actors we are talking about. Are we talking about actors exercising a degree of editorial control over the content they generate and make available, or are we talking about intermediary service providers once again? So let's try to understand better this point. The question, and then at the end I will try to answer the question that we have to address here is whether the DSA is a good fit for generative AI. Indeed, in legal literature, there are some views that the DSA will be already equipped to cover some generative AI systems, and particularly LLMs. For example, this is the theory advanced by Beatriz Potero Arcea in a paper back in 2023, so before more recent developments, based on the interpretation of the notion of search engine service under the DSA. If you look at the definition that it's here in this slide, you can notice that an intermediary service that allows users to input queries in order to perform searches of, in principle, of websites or web websites in a particular language on the basis of a query on any subject in the form of a keyword, voice request, phrase, or other input, and returns results in any format in which information related to the requested content can be found. It's, as usual, in the language of the European Union institutions and the EU law acts, very long, detailed, and this is perhaps reflecting this attitude that we see in EU law, that we want to regulate everything in every detail, which sometimes is definitely not so beneficial. But anyway, no matter whether this is a good or bad definition, we have it in the DSA. And as you can see, there are certain particular characteristics that we can spot, in particular, the fact that there are input queries that can be performed searches based on the content of websites or certain websites, and the fact that these services are returning results. And these results are provided in any format in which information related to that requested content can be found. So this definition seems to be quite agnostic to the particular format in which the information is returned. So we are definitely familiar with search engines that are returning information in the format of URLs or links to third-party websites. But if you look at the definition closer, you notice that we shouldn't take it for granted. So maybe what ChatGPT does, providing, for example, a short summary of content it could retrieve and summarize online, is in a way compatible with this notion. It's a result. It's a result in a format in which the information related to the requested content can be found. So, if the notion of online search engine is agnostic to the format, we should maybe acknowledge that they don't work so differently from search engines. When we are thinking about Gen AI systems, there is an input. There is generally consisting of a prompt that users are providing, and there is some processing of that information resulting in outputs that is returned. So we could say, oh, maybe the DSA already covers some Gen AI systems. And of course, if this is the definition that we expect to apply to search engines, we could argue, as Beatriz Botero Arcila did in this article, that to the extent Gen AI reaches significant market presence, and perhaps as in the case of ChatGPT, they reach a certain threshold in terms of number of users, then they can qualify as very large online search engine. However, for a while, this hasn't been discussed so much. And this was maybe some academic research that I also conducted myself in some articles. But practically, the problem wasn't discussed in detail and so much in literature. However, now it seems that the European Commission announced to consider the possible designation of a ChatGPT service under the DSA, most likely under the umbrella of Velos, so as a very large online search engine, given that it's the search functionality that reaches so many users. But at the same time, we should discuss whether maybe it's maybe not really a search engine, but more a general hosting service. And so, if these are very large online platforms, we will also consider some particular aspects now in this definition. So, can we say that Gen AI systems qualify as intermediary services? Because, of course, the article by Beatriz Botero Arcela was quite straightforward and coming to the conclusion that maybe there is room for including them in the scope of the definition of search engines. However, we should reflect, in my view, on the compatibility of the nature of Gen AI systems with the nature as intermediary services of the services under the umbrella of the DSA. As you know, the DSA applies to intermediary services. So, is Gen AI something that can qualify as an intermediary services? Indeed, if you look at the DSA, you know that there are three main categories of services: merconduit, caching, and hosting services. And we can say that VLOP and VLOS fall under the category of online platforms, and of course of those of hosting services at a higher layer. But it's quite clear that even stretching the definition of search engine, they are not the services that at least the lawmakers that drafted the DSA had in mind. There is also another aspect that we can discuss regarding one of the characteristics of online platforms or online search engines, the characteristic consisting in the dissemination to the public, which is something that happens when it comes to online platforms and something that happens either when it comes to online search engines. Can we say that a service like ChatGPT disseminates to the public certain output? uh, we can discuss maybe also this aspect. But what I want to highlight and emphasize more is another aspect in these, is the fact that generally speaking, when it comes to intermediary services, we are talking about, as I said before, providers that have no editorial control because they are merely facilitating the dissemination. They are hosting, for example, user generated content. So, third party content. As we know very well, individuals in their capacity as users can post to social network platforms or can upload videos, for example. These are third party contents. And under no circumstance, this third party content is something for which, in case it's illegal content, we can blame online platforms, except for the case there is a notice and then an action that is required under the DSA, and maybe the platform concerned failed to remove that content. You know very well how it works and how it worked before under the e-commerce directive. So this is already a first aspect that, in my view, makes quite difficult to consider the DSA a good fit for generative AI services and particularly for Gen AI systems. However, there is another element in the definition that we can see. Platforms are hosts which store or make available content provided by a recipient of the service. This is what we can see under Article 6 of the DSA. So this could be an obstacle to qualifying Gen AI as VLOP or VLOS, for example. Why? Because we are generally considering, when it comes to intermediary services, uh, services that are, as I said before, facilitating the dissemination, so making available content, but we are talking about third-party contents. And the content we can find on that particular service, whether it's a social network or a user-generated platform, depends on the previous input by the recipient of the service. So they make available something that was provided, generally uploaded or posted by a recipient of the service. In other terms, what you can see on YouTube or on Facebook or X is what I posted, what you posted. So the recipient of the service is let's say, the creator of the content, is the author of the content. However, if we reflect in a more accurate way on the possible way Gen AI systems work, we notice that it's very unlikely that the output that is made available by ChatGPT, for example, is something that the users provided, the recipient of the service inputs. Indeed, as Lillian Edwards and other colleagues of her noted in a very interesting article last year, the only content that the user supplies is the prompt, or other inputs, maybe some content, images, databases, text. And, you know, storage of this is not the relevant information society service that the model provider is offering. So it's not the storage of the prompt, if it happens, if it occurs, the information. There is nothing similar and comparable to what happens, for example, on user-generated content platforms, because the prompt is a request to provide something in return, and we can't compare, of course, the provision of a prompt that is input by the users of ChatGPT to the content that we upload on YouTube, for example. I think I made the point very clear, but we can discuss it later if you want, if you have any specific question about this. I repeated many times, so I guess it was a bit redundant. There is another point that we should discuss, but I will save you from a specific conversation on this. But it's about an article that I recently wrote and published about the problem of determining if we have indeed a speaker when it comes to Gen AI output. Why I want to focus on this problem just briefly, because you see in this slide, I mentioned the fact that generally speaking, the content that we see and we can find available on this providers of intermediary services, so online platforms generally, is a content that was input by the recipient of the services, by users. In this case, when it comes to Gen AI, it gets difficult to understand if there is indeed someone that can be considered as the author of the content we're talking about. In this article, I took the perspective of speech. So I explore whether we can consider Gen AI output as speech, even in the absence of a human speaker. But this is not the point that is most relevant for our conversation. I think that the point is there anyone that might be qualified as a speaker here? Maybe those who are prompting uh, systems, Gen AI systems, and asking ChatGPT, for example, to provide a given output. Maybe under certain circumstances, we may consider them uh, a speaker, but this will imply a very important problem in my view, which is setting a line and drawing a red line between the circumstances under which we have a human speaker that's contributed to generating a particular output and therefore might be considered as the author of that content, and the circumstances where indeed there is no possible attribution of that output to the prompter. So this is a problem that is currently addressed, for example, under copyright law, because in copyright there is a discussion on whether we can recognize and identify a creator that is a prompter, but is prompting many times the system in order to get a certain particular output. Here we could have a similar problem in terms of speech. So um, can we think that there is a speaker? And also, one of the most radical consequences of considering that we have a speech but we don't have a human speaker might be that, of course, some content that we may feel illegal because, of course, for example, they are defamatory, and that's defamation, it's something illegal, may no longer be illegal because there is a lack, and they lack mens rea, which is something that we need to assess in criminal law, for example, for human speakers. So we may paradoxically come to the result where a given output is something that, if authored by a human, is illegal and might imply mens rea. If it's not uh, the result of a human speaker, is not illegal just because there is no mens rea. So, of course, this will add more complications. But I just want to uh, give you the sense of the complexity of aspects and issues that we have around this point. So I think that we need to reflect more carefully on whether the Gen AI system engage in content creation or they merely act as intermediaries. So we need to reflect, of course, on the role of users and prompters. We should think about the role of output filters because if we take it for granted that maybe there is no editorial activity, there is no content creation, which I'm not so sure. We may discuss also if the use of output filter consists in editorial. Like if we want to prevent Gen AI to say something because it's defamatory, for example, to use certain particular words, words that are generally part of hate speech or discriminatory language. Is this a kind of editorial activity in which Gen AI systems and their providers are engaging, which may trigger some consequences? So the point is, are we talking about content providers? Because if we are talking about them, about Gen AI systems in terms of content providers, the consequence should be that the legal framework for content moderation under the DSA shouldn't be applicable because, as we said, that framework concerns intermediary services. And accordingly, if we have something which is different, it's not a mere service provider, but we have a content provider, the liability exemption wouldn't make any sense. But at the same time, as we said, we have the AI Act, which is specifically calling for the application of the DSA when Gen AI is integrated into services under the umbrella of the DSA. So what can we do? I believe that at the end of this overview, I can make a proposal, which is, in my view, a stick and carrot approach. And now I'm going to conclude, of course, so there will be time for a Q&A. I believe, honestly speaking, that it's very difficult to stretch the DSA to the extent that it becomes applicable to Gen AI services without possible inconsistencies. Honestly speaking, I find it difficult to consider that at least certain Gen AI systems are intermediary services. But notwithstanding the above, I will say that applying the content moderation regime and the liability exemption for illegal content will not be so bad, will not be a bad idea. Why? Um, just let me say that there are commentators, for example, Philip Hacker, that call for a selective application of the DSA to Gen AI. This will imply, for example, that we can manage, when it comes to Gen AI, in particular outputs, we can manage this content according to the same mechanisms under Article 16 of the DSA, a notice and action mechanism. So we can flag a given output, and the provider of that system is aware at a specific time that there is something illegal there that might be illegal and accordingly is required to take action. Maybe in that case, we can apply content filtering, output filtering in particular, and that will be a useful solution. So there is no direct and strict liability for that output, which also because of the black box effect wouldn't be, in my view, nonsensical, will make sense indeed. But at the same time, we have a notice and action mechanism, but we apply the content moderation through this possible combination as suggested by Hacker, so a decentralized control and a centralized control as part of the notice and action. And to support my argument here, I want to mention the DSA. I mentioned the DSA, but I want to mention the parallel provision of the DSA in the US, which is the Communication Decency Act. The Communication Decency Act was introduced in 1996 in the US, and it was basically supposed to shield online service providers because uh, in the US, they wanted to encourage content moderation. They wanted to encourage content moderation. So if you look at the CDA now, of course, the alternative is quite clear. Either you are a content provider or a service provider. And it's very likely that a service like ChatGPT will fall within the category of content providers here. But Section 230 was introduced exactly to encourage content moderation. So the idea was we shield you from liability because we want to make sure that you are, in a way, comfortable in engaging in content moderation. So if our expectation is that Gen AI systems, especially in the European Union market, can be a relevant industry and the relevant markets, and this is something which I address and other colleagues address, for example, in some SER research, the Center on Regulation in Europe, recently with a focus on the DSA and competitiveness. We need to understand that maybe a liability exemption would be good because it wouldn't attribute direct liability and a direct infringement, let's say, but will just stimulate content moderation to make sure that the content that we have online and in this particular services is a content over which the relevant providers can exercise some degree of control. So my conclusion is that applying liability exemptions and content moderation maybe is not the most coherent interpretation of the DSA, but it's not so bad. It's not so bad to the extent we are talking about VLOP and VLOS. We should discuss whether certain systems fall under one of the either category, because of course it's not that easy to understand whether they are search engines or online platforms. But I believe that uh, avoiding direct liability for certain ambiguously characterized acts of content creation will be good while incentivizing content moderation, exactly like Section 230 did in the US at the early developments of the internet. This is the reason why I support this conclusion. Section 230, in the words of Jeff Kosseff, an American scholar, were the 26 words that created the internet. It was backed in 1996, of course. Now we are maybe approaching AI at the same early days, and maybe something similar would be beneficial for the industry in Europe in particular. Thank you so much for your attention, and I'm happy to take any question you might have.
Thank you so much, Marco, for such a dense presentation. The topic is so relevant and it had already stimulated quite some questions um, on our Slido. I invite other people to connect as well, so they can ask and vote for the questions. Let's take 10 minutes for the Q&A and start with the first one that we see on screen. So, do we need a new legal category beyond intermediary and content provider to capture Gen AI systems, in your opinion?
This is the question, indeed. This is the question. I honestly believe I'm very supportive every time when it comes to technology and legal developments. That's we should first of all resonate with the existing categories, and this is also one of the reasons why I try to delve into what exists in the DSA. And I believe that if we can find a rationale in the end in making the DSA applicable to Gen AI. Why not? I do believe that there might be specific features, specific functionalities of Gen AI that may already be covered under the DSA. For example, to the extent that system is used for a search engine, I believe we don't need a new category. But when it comes to the content creation aspect, I honestly think that it's really a point to be discussed. I don't have an answer right now. What I will say is that we should maybe understand more from a technical perspective what's going on. And what I'm scared about is that regulators take certain initiatives without a deeper understanding of what we can consider. So, for example, understanding whether this is a genuine creation of content, in my view, is a preliminary step before deciding on that particular question. That is my take. I don't know how many questions we have, Maria Joanna.
Thank you. We
Just
have a few. We're gonna
okay,
do our best to address as many as possible, but
okay. I will try to be quick then. It's that's fine.
all right. So the next one is, do you think the European Commission will designate ChatGPT and other LLMs as VLOPs? If this happens, how would the reporting of illegal content work since it will happen in private conversations with the chatbot?
Yeah,
So,
this is a point also because we know that the DSA is not applying to, it does not apply to private messaging services. So, for example, Telegram or other similar services, and maybe the kind of interactions we are having sometimes it's an interaction that might resemble, you know, that particular kind of services. And I have no answer in the sense that I am honestly speaking reflecting on whether the VLOP or VLOS will be the most appropriate option. My feeling is that the Commission is going for the VLOS option. So in a way, maybe Beatrice Botero in her paper, uh, I think, reasoned quite interestingly on this option, and this was based on the similarities of particular aspect. The illegal reporting, of course, it's something which is quite difficult to happen in practical terms, because if we can report that illegal content, um, we know very well that there are precise settings, so we should make sure that these systems can determine why that particular content was output, which is not always easy, and the fact that we expect that conversation to be private will make it difficult, because we expect that there is nobody else except for us, let's say us in terms of recipient of the service, to be involved. Maybe I will say the extent to which we can report that content, it might be in a way to report the malfunctioning of the system, just to say, I noticed that a given output was reported as a result of the private conversations under these conditions. But it will be very difficult. I take your point.
Of course. And I mean, maybe I can go to the bottom question that we see on screen, as we can maybe relate in part to what you just said.
Mhm.
Someone asks, isn't there a risk for an excessive deresponsabilization of platforms and over responsabilization of users? I mean, isn't there always?
Yeah, that's the risk indeed, in the sense that, of course, I understand also that my claim is quite strong, because if you say that ChatGPT or similar systems and the providers shouldn't bear consequences for a given output, I understand that it may sound very protective for them and not very protective for users in the end. I'm just trying to reasoning on the consequences at large that on that particular market may derive from the choice of establishing, for example, a mechanism like direct liability, strict liability, because I don't think that strict liability will be the solution because of the black box. But once again, going back to the first question, the point is understanding whether this is a creative activity, because as we know very well, if that's why it's a preliminary point we need to understand. If that is creation, then we can say, oh, this is direct liability will make sense, right? Because we know that you have editorial control over the content. But to which extent we can claim that currently operating Gen AI systems have editorial control over their creation, let's call them this way, in my view, is very difficult to determine.
Of
But I
course.
see the risk, of course.
All right. Some other attendee asks, um, sorry, I really wanted to get your opinions on this one. Could some Gen AI systems already fall under the definition of online search engines due to how they retrieve and synthesize information, and what happens when ads are introduced in replies?
Oh, that would be interesting. I guess yes, they can. As I said before, the notion of search engine seems to be agnostic to the format. So that will suggest that, um, yeah, in the end, they can fall under that definition. Of course, um, once again, the definition is format agnostic, but this doesn't mean that lawmakers, when they drafted the DSA, hadn't in mind something which is not ChatGPT, for example, which is not that particular service. They had in mind, of course, other search engines that are very popular commercially on the market. So we can stretch it. But I would say that if you retrieve and synthesize information, the problem is the retrieval is fine. The activity of synthesizing information still creates the same problem. You are creating something, and similarly for the introduction of ads in the replies, because then it even turns in, is it commercial speech? And so should be subject to certain particular strictures. Again, I don't have an answer for that as well. Sorry, I sometimes I wanted to trigger a conversation, but it's really difficult to see the extent to which DSA and AI systems, Gen AI systems in particular, can let's say overlap without any possible issues or lack of consistency.
course, but you do convey the complexity of the topic. Let's take two more questions before we close. One of which is we are debating whether AI systems should be legally bound by the DSA, but what about the reverse? Should platforms be required to comply with the AI Act as deployers of AI systems? For instance, Glock on X, Meta's AI, etc.
Yeah, I think this is something which already is in a way happening because to the extent they are running the systems, they can't escape from the obligations under the AA Act, of course, as well. The problem is understanding whether there is more in terms of systemic risk, for example, and the intersection of these frameworks. For example, now the Commission is launching this investigation for growth because this is something which consists in the dissemination of illegal content, because nudifying people in deepfakes is definitely something illegal. So, of course, it's the application of the DSA that is coming into play, but we shouldn't forget that that particular service is per se something which already should trigger the applicability of the AA Act. The point is also, you mentioned the deployers. Sometimes they might be at the same time deployers, maybe providers as well. So it's also understanding which role. Yeah. But anyway, it's another point that we should add to the conversation.
Right. And the very final question, can we meaningfully speak of speech without a speaker in legal terms? And I think this also triggers some curiosity from the researcher's perspective in
Yeah,
terms of lack of transparency and understanding
sure.
what gets these systems trained. Yeah.
Yeah, I mean, the easiest way would be I would suggest reading my article and see what how my claim is articulated. But in a nutshell, long story short, the point I try to make in that article is not that we don't have a speaker, we let's say at all, but we don't need a human speaker. Let's say my point is slightly different. So my point is that in the absence of a human speaker, um, that is comparable to everyone that is speaking publicly and exercising free speech rights in the real life. I believe there are reasons and avenues to protect certain outputs of Gen AI as speech. Then we may have also a speaker. And as I said, the problem is this a company? Which we know that, for example, in the US, the Supreme Court's held that also corporations can have free speech rights. More recently, in the Net Choice and Paxton cases 2 years ago, concerning the content feed of social networks. So it's an interesting point. Or maybe we could argue whether the speaker is the prompter in some particular circumstances, as in the case of copyright, maybe when the result of certain prompting is a given content. Or maybe we could argue, I do believe we have reasons to support also the idea that we might have speech even in the absence of a speaker. Also because, and this is what I suggest in the article, freedom of speech is freedom to inform, is freedom to disseminate content, but it's also freedom to receive it. So in a way, I think it's also the other perspective that may support a finding that that content is speech because it's perceived as speech, no matter whether there is not a human speaker behind.
All right.
Or even a robotic speaker, let's say, which we can qualify as the speaker per se.
A lot of layers. Um, All right. I think we've now officially run out of time, so there are still a few unanswered questions, but many dilemmas open definitely in this engaging topic. I would like to thank you so much, Marco, for sharing your expertise with us. I would like to also thank our attendees for asking many questions and being always so engaged, and my colleagues Heini and Lucas behind the scenes for making this webinar possible. I take the opportunity to remind you of our upcoming webinars in April, starting from a presentation of our EDRN project on April the 2nd on how civil society can defend itself. For the evidence and enforcement series on the 9th of April, we will dig more into the DSA with evidence of the experience of AI forensics. And on the 23rd of April, we will be back to speaking about OSINT with a case study on decoding Russian intelligence, OSINT and FIMI. I encourage you to register already for the next webinars on our website. As mentioned earlier, the recording for today's session will be available soon on our YouTube channel and website as well. And you can also find all of the previous webinars recordings. If you do not follow our biweekly newsletter, you're definitely missing out. So I really invite you to subscribe. And finally, at the end of this webinar, you will be presented with a feedback questionnaire. Please do rate the webinar, suggest further topics, let us know what you think, and I'll see you next time. Thank you so much. Goodbye.